Hi, everyone. Welcome to this evening's presentation. This evening, we are speaking with Doris Benora, and we're going to be speaking about getting the paperwork in order. And of course, this is kind of as we are talking about dying with dignity, the paperwork we are speaking about is the paperwork upon death of someone living with dementia. And so Doris is going to be able to help us out with that. Before, as we usually do, I do want to just ask a question, and it really is just where everybody is from. The one thing you will not see is if you are from someplace other than whether it's Edmonton, Fort McMurray, Red Deer, Grand Prairie, Calgary, Lethbridge, Medicine Hat. If you're from someplace other than that, just feel free to type that in the chat box. We'll give everyone just a couple seconds and then we'll carry on. So we do have 6 people from Edmonton. Okay, great. So it looks like everybody, Doris, is from Edmonton.
Okay, perfect.
So this evening, some of the goals that we hope to cover is that you'll know what paperwork needs to be done immediately when death occurs. You'll understand the duties of an executor of an estate. You'll understand when probate is needed. And we're also just at the very end, after Doris is finished, we're just going to take a couple minutes and just talk about making some plans for the future after someone's caregiving journey is completed. So that's kind of our plan. So I'm going to now turn this over to Doris, and she is going to walk us through it, everybody.
Well, thank you. Just to tell you a bit about me, I'm a partner at Dentons Canada, and I've been practicing for 30 years in the area of wills and estates. I love my volunteer work with the Alzheimer's Society, and I've been on the board, and now my volunteering involves teaching these seminars, both at the beginning stage of the disease and then at the end stage. So please feel free to ask lots of questions as we go through this. I'm going to try and cover the whole estate administration process and the questions I normally get asked, but please feel free to ask questions as we go. So the first question I'm going to ask you, just so that we perhaps get an idea, is do you know if the family member who is living with dementia in fact has a will?
And so everyone, what we're going to ask you to do is right above the chat box, you will see a smiley face. If you click on that smiley face, you will see you have the option of a thumbs up or a thumbs down. And so mark a thumbs up if yes, they have a will, and a thumbs down if no, they don't. It will just help Doris when she presents.
Okay, so very good. So to know that everyone has a will. Sometimes the wills still have problems in them, but it's a good place to start with a will. So we're going to start with these steps to take. Knowing that you have a will is one thing. Locating it is, of course, the next step. So right now, because you perhaps are in preparation for someone to die, it would be good to locate not just a copy of the will, but the actual original will. And so people keep their wills in lots of different places. Many lawyers who prepare the will would keep the will, the actual original will. So if you know who prepared the will, you might find it there. People keep their wills in safety deposit boxes, under their mattress, all kinds of different places. But it is important that you try and locate the original will. If you don't have the original will or can't find it, there's ways to advertise in legal newspapers to find them, but otherwise it's possible that we can still be able to deal with a copy of the will if we're certain that the original will wasn't destroyed completely. If it was destroyed, it's possible that the person who made the will is saying they don't want that will to be in place. So immediately more complicated if you don't have the original will. The next thing is to determine the identity of who the person is, who is the executor or the personal representative. In Alberta now we call them a personal representative. Most people know them as the executor, but it is the person who's going to be completely in charge of all of the affairs when someone dies. And it's important to know that person because they are the person who is in fact in charge in terms of planning the funeral. And that's the first thing, obviously, that you need to deal with. If there's no executor named, perhaps you have an old will and the executors that are named are no longer valid, or they've died, or they're too sick to do it, then the next of kin, starting with a spouse, and then the children, starting with the oldest child, are the people who have the right to plan the funeral. But of course, you know, we live in complicated times, so if you have a family that is not getting along and perhaps there's a second spouse and then there's children who are fighting, it's always the executor who has the ultimate say in how a funeral is planned. The reason we want to locate the will right away is because many people will put instructions about their funeral in the will, or they might have a letter or memorandum attached to their will about their funeral. Lots of people will keep instructions about if they've prepaid a funeral with their will, and so that's why we normally want to locate that right away, because we want to see if there's some instructions around that funeral. I find that lots of people think they should not read the will until after the funeral is done because it signifies that you're thinking about money before the person. But my view is that if you don't read it, you may miss some instructions in respect to the funeral, and certainly you'll miss who's in charge in terms of who ultimately has that authority. Once somebody dies, I think lots of people think they have to move really quickly and get things done quickly. And certainly I think for some people that's therapeutic and they feel good about getting things done quickly. But I would say the one thing that is important to do other than the funeral is to cancel any identifying information such as driver's license and passports, SIN cards, Alberta healthcare cards, banking cards, and anything related to the bank, and notifying the banks of the death. And the reason for that is it's very unfortunate, but there are in fact people who read the obituaries and then attempt to commit fraud on someone who's deceased because they can't defend themselves. So if you start to cancel that identifying information by just making a phone call or writing a letter to say that the person has died, and you notify all of the financial institutions that the person has dealt with, then you pretty much have protected yourself from any kind of fraud in respect of someone who has died. One of the questions we always get is, what should I do about paying bills after somebody has died? You'll see in point number 2 that the enduring power of attorney ends on death. So at the moment of death, the executor or the personal representative takes over. I often get calls from people that say, you know, my mom died, but it's okay, I'm still the power of attorney, and so I won't have any trouble with going to the bank and paying bills. But in fact, because the power of attorney ends, you don't have that power anymore. So before you get a grant of probate, and we're going to talk all about grants of probate and what they mean, you can take bills that the deceased owes to the bank and request the bank to make payments. And so this will work for anything like funeral expenses, credit cards, and utility bills. Lots of people are very concerned about those funeral expenses because they can be very expensive. And so your ability to fund that on your own and not have it come from the deceased bank accounts can be quite alarming, and so that it should not be a concern for you. And I know I have lots of clients who say, I think I'll just set up a separate bank account so I have money there to pay my funeral, and you don't really need to worry about that because the bank will absolutely issue a bank draft to pay those funeral expenses. After you get a grant of probate, the executor will have access to the bank accounts and therefore will be able to pay any and all bills. So it's just during that period before and after, before the grant of probate, where there's potentially a problem to deal with payment of bills. So in terms of estate administration, how many of you are both the attorney under the enduring power of attorney and the executor? And so you're going to go back to that smiley face and press thumbs up for yes and thumbs down for no.
For the new person who joined, if you find the smiley face under the chat or just above the chat box, if you push that, we're just asking people to respond with a thumbs up or a thumbs down, whether you were the enduring power of attorney as well as the executor of the person you're caring for.
So it looks like all of you were both the enduring power of attorney and the executor, and that is normally what we would recommend as well, because it makes sense that if you are an attorney under the power of attorney and managing finances, that you're going to carry on and continue to manage those finances and administer them even after the person dies. So that's a very good situation for most people to be in, and then it doesn't mean that that there's no real transfer of power from an attorney over to an executor. So the question I get asked the most often in respect of dealing with estate administration or death is, do I have to probate? Usually they ask that question first, and then they say, but what is it anyway? And so the answer in terms of do you have to probate really depends on how assets are owned. But let's start with what it is. So a grant of probate is a grant from the court that confirms the will and gives notice to those who have claims. In terms of confirming the will, the court will actually take evidence in a paper application and confirm that this is the will we're going to follow, and therefore this is also the executor who's appointed and who has power. And there's no court appearance that's necessary. It's all done by way of a paper application. But once that grant of probate is given, then banks and land titles and anyone you want to do something with will be able to rely on that grant of probate as the person, showing that the executor is properly appointed and showing that there is a proper will that we're going to follow. In Alberta, in Canada, if you have money in the bank in your own name that is greater than $10,000, for the most part, you're going to have to get a grant of probate. If you have land solely in your name, there's no question that you will have to get a grant of probate in order to deal with land. So you'll have to apply in order to be able to deal with those assets to either sell them or transfer them into the names of the beneficiary. So thank you to our newest guest who also said she was the exclusive power of attorney, personal directive, trustee, and executor. So that's when, if we find that when usually with a married couple, so if one person of a married couple dies, they may have all of their assets in joint names. They may have a named beneficiary on their RSPs, their RIFs, their pensions, tax-free savings account. In those cases, you may not have to apply for a grant of probate because there are no assets that are solely in the name of the deceased where there's no named beneficiary. And so it really just depends on how assets are owned to determine whether you need to apply for a grant of probate. In terms of how long it takes, it's usually about 2 to 3 months. I just heard today from the courthouse that they're taking a bit longer because there's a shortage of judges at the courts right now, and so things are taking a bit longer, especially if you make any mistakes, because if you make a mistake and they reject your application, you go to the bottom of the pile, and so some of these are taking a bit longer. In fact, some are up to 6 months, but generally you're in a 2 to 3 month range, and I think that surprises most people because I think most people think that probate takes a much longer period of time. So in terms of applying for a grant of probate, it's done through a legal process where you're going to put together a series of forms called the application, and that application gathers all kinds of information about the deceased, about the deceased family. Do they have a spouse? Do they have a girlfriend as well as a spouse, or any of those things that complicate estates and families? We want to know who the children are, whether there are any disabled children, all of those people who might have claims on the estate. All of that information is gathered into one application. It's sworn under oath so that it's treated like evidence in court and then submitted to the court. The clerks of the court review it. If they find it's acceptable, they'll give it to a judge. A judge reviews it. If they're satisfied, then you'll get what's called the grant of probate, and it's that document that you'll present to banks and land titles to get authority to act. And so number 5 is basically answered, so that grant of probate allows you access to all the assets, to pay bills, distribute the assets to the beneficiaries, to be able to sell the assets. So you won't be able to complete the sale of a house, for example, without getting the grant of probate.
So Doris, my question to you then, I see the word you must. It sounds like then if I was to fill that out, I could potentially make a mistake. Is this something that if I have a lawyer, I would want the lawyer to assist me with, or is it a fairly straightforward application form? And if it is, where do people get this application form?
So I would say that this is a legal process that is more complicated, and most people will hire a lawyer to do it. So when we say application, I hadn't thought about the fact until Arlene said it, that you might think it's kind of like a one-page application, like applying for Canada Pension Plan. But in fact, it's a multi-page application involving a series of forms that you need to put together, and you have to know all the notices that you have to give, and then it has to be put together in the right order, and there have to be stamps on the back of the will. So it is something that takes a fair bit of effort to know how to do and to get it done. Of course, you can always do your own legal work. That's, a given. If you commit a murder, you can certainly try and defend yourself. Generally, people will hire a lawyer because they find the process quite cumbersome and lengthy, and the people they hire as clerks to review these applications are clearly the most anal retentive people on the planet. So even if you make one typographical error, even if it's obvious that it's a typographical error, they'll probably reject your application, and then you have to redo it and resubmit it. So I find lots of people try and then fail, and then we get the application to complete. If you were going to try and do it on your own, you could get if you went to the surrogate court, they would give you all of the surrogate court forms, and then you'd have to figure out which ones needed to be put into the application for probate. Often the whole issue of who gets a copy of the will is something that is a question people ask, and I think lots of people think that the will should be a very private document and that not very many people should get a copy. And then when you ask for a copy, you're seen as someone who's, a money-grubbing person who wants a copy of the will. But anyone who's a residual beneficiary, meaning if you're going to get a portion of the balance of what's in the estate. So for example, if you had a will that said, I give $10,000 to the Alzheimer's Society and $10,000 to my brother, and then I'm going to give the rest of my estate to my nieces and nephews, the nieces and nephews would be the people who get a copy of the will along with a copy of the application for probate. But what if somebody wants to see the will and they're not a beneficiary, or they are a beneficiary perhaps for the $10,000, but they're not a residual beneficiary? There is actually no obligation to produce the will, but my view is if somebody's asking for a copy of the will and they aren't just some crazy busybody, then the best thing to do is to provide them with a copy, because the open communication always is the best approach in estates. The minute somebody starts to say, I'm not showing you, is exactly the time when people think there's something to hide, and they're hiding something that they don't, that is a benefit to that person. The other thing that you should know is as soon as the application for probate is filed, which most estates, especially on the second to die of a couple, are probated, that is a public document. And so that's why we get to learn about celebrities' wills, is because when they go to probate, those wills are all public documents, and then you can read them. And so if you saw, someone in town who died and you thought you really wanted to know what their will said, probably if they probate their estate, you'd be able to find that will. So then again, the fight over who gets a copy seems to be a fight that's not worth having, because potentially if you're probating, they're going to get a copy in any event. Okay, so feel free to type those questions in if you have any. The big question lots of people ask are, what are the taxes that have to be paid? Because you've heard that adage about the fact that there's two things certain in life, and that is death and taxes. And unfortunately, the taxes have to be filed even after you die. So the executor must file a tax return for any previous year that hasn't been filed. And they also have to file a tax return for that portion of the year that the person lived. So if you die in, say, February of 2015, he would have to file a tax return for 2014, because they probably wouldn't have filed their tax return yet for 2014. So you're going to have to do that one. Just as the person would have done if they had lived. They would have lived in sometime in April, they would have filed their tax return like everybody else. But then you also need to file a tax return for that portion of 2015 that the person lived. So from January 1st to February 28th, 2015, you have to file a tax return for that little stub year that they lived. And again, that tax return is for the income that is earned in that year, but it's also a bit more of a complicated tax return, because when you die, you're deemed to sell everything that you own. And so, for example, if you have an RSP, you're deemed to cash it in. If you don't have a spouse that it can go to, that's going to be taxable income. So I would say that if you're going to be concerned about taxes, and if you're not an accountant, the tax return that involves the stub year, the portion of the year that you are that the person was alive, that's probably where you'd want to get an accountant to help you, because that's a more complicated tax return. And then the executor must also file a tax return for any income earned in the estate after the date of death. And if it carries on for a number of years, then the executor must file a tax return for every year that the estate is in existence. So lots of people think, well, how could they earn income after the date of death? Well, the big one that everybody, almost everybody has if they've worked, is there's a Canada Pension Plan death benefit that you get after you die to help with funeral expenses, and that's income for the deceased. So even that it's a small amount, $2,500, but that's income for the deceased. Also, from the moment your bank accounts, like the day after you die, as long as you're earning income in your bank accounts or your investments are growing, all of that will be income to the deceased. So you for sure have 2 tax returns to file. You may have more than 2 tax returns to file, depending on what time of the year that you die. And if the estate carries on into existence, you'll have as many tax returns as the estate carries on. So if it's in litigation or if it's complicated, you might have more. The other thing that happens, going back to the first point, is sometimes you have people who just forget to file their tax returns for many years before they die. And the executor also has that problem. They have to deal with all of those tax returns. The one thing we're also noticing is we have sort of deemed Americans, lots of deemed Americans who have to file American tax returns. So if you had a mother who was American, or if you have lived in the U.S., or if you have a U.S. passport, and some of those people just say, I'm not filing my tax returns in the U.S. I'm just not going to. I think that's stupid and I shouldn't. And that's fine for them to do, because they can live with those consequences. But as an executor, you're going to be obligated to file those tax returns. We actually had a set of farmers, so a son and a dad, and the dad died at 99, so his son was like 78 when he came to see us because his dad had died. And so I asked them when they last filed their tax return just to figure out exactly which ones we'd have to file. And they said, well, we never filed. He said, well, we never filed. And I was like, no, like you're farmers. You have like a gazillion things you have to file for. And he said, yeah, my dad and I have farmed. My dad farmed, from the time he was 18, and he's never filed a tax return. But he brought along 2 boxes where they literally had put every receipt for every single thing they had done in Ziploc bags and labeled the years, and they put them in the boxes. So they actually had kept all their receipts, and so it made it somewhat easy for the accountant. But it was quite astonishing to me that 2 farmers could fly under the radar for their whole lifetimes and not file tax returns. So we have a question, and the question is, does the total value of the estate without land holdings have an impact on the term of time it takes to probate in Alberta? So the answer to that, I would say, is generally no. I would say the time, in terms of probate, getting the grant of probate is just that application. And so you're going to put the values of assets. If you don't know the value of assets, you can put a to be determined and then file something later. But I don't think that impacts on the time it takes to probate. But let me just change your question slightly. Would the total value of the estate without land have an impact on the time it takes to administer the estate? So let's say to get from point A, which is the point of death, to point B, which is final distribution. I would say that obviously larger estates can have an impact. There may be more complicated tax situations. You might have a corporation that may make it more complicated, but really the complication comes from the fact that you have beneficiaries that cause trouble. If you don't have beneficiaries that cause trouble, or you have maybe just one beneficiary, probably the value of the estate will not have a large impact on the time that it takes. I will say land actually can cause a bit more trouble in terms of administering because you have to sell it. And if you have land holdings that aren't just a normal house, I mean, you have a house in Edmonton or in a city and you can get it valued pretty easily and then put it on the market, probably that's not going to hold you up very much. But if you have farmland that you have to sell, or you have a cottage that you have to sell, or you have commercial buildings, those will take more time because you're going to have to get them valued, even to determine how what the listing price will be, and those are more complicated in terms of accepting offers on those and then closing those deals. I can tell you for farmland in Alberta right now, we rarely list it with a realtor because farmland is so popular. So many farmers are out there looking for farmland that we now usually just do it by a public tender. And we are getting fantastic prices by doing that and saving lots of real estate commission. So just carrying on with the taxes. So after you file let's say that you're just going to file a tax return for the year of death and then an estate return and just one return. And after you get your assessment back, you have this ability to ask for something called a clearance certificate. And most executors would want to get a clearance certificate because it basically shuts the door on taxes that may be owing. So an executor is responsible to make sure the taxes are paid, and an executor should not distribute money until he's pretty certain that most of the taxes are paid. Because if he distributes money and doesn't keep enough money back to pay the taxes, then he could be personally liable. So I often get this question, does an executor ever have to pay the debts of the deceased? And the answer is no. The only debt that you might become personally liable for would be taxes, and only if you distributed the estate assets and didn't keep enough to pay the taxes. So paying taxes is pretty important to an executor. Once you're satisfied that you've paid all the tax, you can ask for this clearance certificate, and it basically seals the deceased tax file and then protects the executor from any more liability. The only bad thing about the clearance certificate is that it takes a long time to come. So you will file the tax return, you'll get the assessment back in a few months. Once you have the assessment, you can ask for the clearance certificate. And unfortunately, the clearance certificate takes up to a year to come back. So generally what we'll do is distribute most of the estate, hold back a portion of the estate. The accountants will give you some idea of how much to hold back. I like to use 10% as a rule of thumb. And then you just hold that 10% waiting for the clearance certificate. Once you have the clearance certificate, then you distribute the rest of the estate. But we don't like to hold up the distribution. It's nice to get assets out of the estate as quickly as possible. Beneficiaries like that, but as an executor as well, the sooner you get those assets out of the estate, the sooner you will have no more responsibility. The longer you keep them, the more trouble you have in terms of keeping them insured and making sure they're safe and trying to figure them out. I have a question that says, I learned from living in BC the past 10 years. Just remember, BC is just weird, but let me start again. I learned from living in BC the past 10 years, the probate cost was a percentage of the estate and value of the assets. In my dad's case, this was a considerable fee. Does Alberta use the same formula for fees? Is it a fixed cost regardless of estate value? So yes, living in Alberta is still an advantage despite our change in government. So in Alberta, we don't have a probate tax like they have in BC and in many other provinces. So Alberta has a sliding scale, but it starts at $25 and ends at $525 for any estate over $250,000. So the most you will pay in Alberta is $525 for the probate fee. Now that doesn't count legal fees, but we'll talk about legal fees in just a minute. Please feel free to keep typing questions and love the responses. The question said, or the response was, what a bargain, yay for Alberta. I agree. So now, in terms of estate administration, so someone dies, you've done the funeral, you've done the probate. What else do beneficiaries get to hear about? Does an executor have to report to beneficiaries? So the answer is yes. And that reporting can take all different forms. So we kind of consider the application for probate as the first reporting because that's going to give people information about what the will says, who the beneficiaries are, what the value of the estate is. And so that's the first report. After the grant of probate comes, usually you do another report to beneficiaries to say, now we have the grant of probate and here's our plan for moving forward. As a rule of thumb, probably you would report to beneficiaries about every 6 months. And really, sometimes you're just reporting because you have now a significant step. If you have done the taxes by the time you have your grant of probate, you might be in a position where you're actually going to do an accounting and suggest a distribution to the beneficiary. So that can count as your report. This is a relatively new requirement. It used to be that executors didn't really have to report what they were doing. So this is a nice change to the law because beneficiaries do want to know what's going on, and it's nice for executors to be accountable. There is also a requirement that the executors must provide an accounting to the beneficiaries. And this is required at least every 2 years, maybe required sooner. Most estates, most regular estates without problems, there's no fighting among the beneficiaries, usually don't take 2 years to get done. They would be done sooner, and the only reason they get delayed is because of that clearance certificate. But otherwise, they could be done much sooner. So if you kind of work hard as an executor and just keep moving things along, you could do an accounting to the beneficiaries, just showing them what money's come in, what money you've paid out, and what you're proposing to pay to the beneficiaries. You'd also set out in that what your executor's fee is, and we'll talk about executor's fees in a moment. And then the beneficiaries have the ability to approve your accounting or not. And if the beneficiaries don't approve your accounting, then they have the ability, or the executor usually would go to court to get the accounting approved. So we don't generally like to go to court. We like to try and avoid court. But sometimes you just get beneficiaries who are disagreeable, and then unfortunately court is your only answer for solving that problem. So let's talk about problems and can a will be challenged, because that's a question we often get asked. It's still difficult to challenge a will in Alberta, although unfortunately getting easier. And for our friend from BC, I will tell you that it's much easier to challenge wills in BC. So lawyers in BC have a lot more work in terms of challenging wills, not so much in Alberta. If the person had capacity to do the will, so they did their will either early in the stage of dementia or long before they had dementia, then they would have had capacity, and therefore we're not worried about capacity. But lots of wills get challenged because they believe the person didn't have capacity to do the will. Another way a will can get challenged is on the basis of what we call undue influence, and that is where the person it appears perhaps that there was a rogue who came along and said, leave all your money to me, and otherwise, life will be hell for you, and convince them to leave all their money to them. So there's some classic cases of the caregiver who moves in, and then suddenly the caregiver becomes the sole beneficiary in the estate. Those are those cases of where we believe there's undue influence, although it's very difficult to prove undue influence. And in terms of capacity, it's still people who have mental illnesses can still do a will. So we had a person, there's a famous case in Alberta where a person lived almost their whole life in Alberta Hospital. And if you know our mental health system, you know that they don't keep people in Alberta Hospital very long or keep them there at all unless they are seriously mentally ill. But this person had the public trustee managing his affairs, and so he wrapped up his accounting that he got from the public trustee with an elastic and had a paper around it that said, I want to leave all of this when I die to my relatives in Poland, and he named them, and then he signed it. And the question was, did this constitute a will, and did he have capacity? And lots of his doctors testified about the serious mental illness he had, delusions, all kinds of schizophrenia, but they said he didn't have a delusion about who his family was. He didn't have a delusion about knowing what his assets were, and he clearly knew that you would give away property on death, so he knew what a will was, and so therefore, despite his mental illnesses, he had the capacity to do a will, and they found that that was a valid will. So just because you have dementia doesn't mean you won't have capacity. Just because you have mental illness doesn't mean you won't have capacity. You have to test that. Does the person know who their family is? Do they know what their assets are? And do they understand that they're making a will? And that's the test for capacity. The other way to challenge a will in Alberta is that you have an obligation to support your dependent children and your spouse, or what we call an adult interdependent partner, so someone who's in a common law relationship. So while we have a lot of testamentary freedom in Alberta in the sense that you should be able to do what you want in your will, there is a restriction that you must support dependent children. So those are children who are under the age of 18 or between the ages of 18 to 22 and going to school and supported by their parents, or they're mentally or physically disabled and unable to learn or earn a livelihood. So if you're in those categories, then those children must be supported. Generally, the courts will say as long as that child is getting an equal share of the estate to the other children, probably they won't overturn the will. You must support a spouse or your adult interdependent partner, common law spouse. If you don't, then that spouse will have a claim on the estate in order to be able to be supported for their lifetime in the style to which they became accustomed. So it's not just about basic support. It's not about like bread and water. It's like if you were going to Phoenix every year for 6 months, then that's the lifestyle you're entitled to. And if your spouse doesn't provide that, then there can be a challenge to the will to get that kind of support. Finally, a will can be challenged if you can show that there was a very different intention than what was supposed to be on the will. So, for example, sometimes people write on their wills. Very bad idea, because that just causes litigation. But if someone were to scratch things out and write things over their wills, or they leave a letter that says, what I really intended, I was going to go to the lawyer today, but I didn't get there, and what I really wanted to do in my will is this, potentially those things can cause the court to believe that the person had a different intention, and then the will could be varied. So in order to avoid those kinds of conflicts, it's good to keep the will away from you so you're not inclined to write on it. Keep it in, so that's why we as lawyers like to keep wills in our vaults so that people don't write on their wills. And to try and keep away from letters that show you had a different intention. Otherwise, you might just end up in litigation. And this is new for us in Alberta. It's only about a couple years old that we've been able to really rely on showing that the person had a different intention than what the will said. It used to be the will was the will was the will. So we covered this a tiny bit in terms of what are the costs of a grant of probate. So you see there the charges between $25 and $525 for estates, and it'll never exceed $525. Legal fees, I highly encourage you to think carefully about which lawyer you're going to hire when you're seeking someone to do your grant of probate. You don't have to stay with the lawyer who drafted the will. Most people feel like they go there to get the will and they have to stay there. And I encourage you to call around and find out what fees people are charging, what fees lawyers are charging. There is a tariff which lawyers can charge, which is $2,250 plus 1% of the estate. But this can be really high for simple estates. And I'm not talking about simple being low value estates. I'm talking about, you know, if someone has $3 million and it's all in Canada savings bonds, then that's going to be way too high a fee for dealing with Canada savings bonds because those are a simple asset. If the estate, you know, has a business and a house in foreclosure and beneficiaries who are fighting, that's a really complex estate. Then that fee might be low in terms of what the lawyers should charge. So most lawyers will charge a basic fee for obtaining a grant of probate. So in our office, we charge $3,000 as a basic fee, no percentage of the estate, for getting you to the point of the grant of probate. Then usually we would just quote you on any other tasks that you needed a lawyer to do. Many executors can carry out all of the tasks after the grant of probate on their own. Sometimes they use the lawyer to get the releases or setting the executor's fee, but then you can really limit what you need to pay for. So I encourage you to shop around because I find that some of the lawyers in the city who are the least experienced charge the most. So most of my colleagues who do the majority of the estate work in the city are at the lower end of the fees. So it's good to check around. So can an executor charge a fee? Yes. And I think the executor should charge a fee, not just that they're entitled to charge one, but that they should. So generally, an executor is going to set their fee on the basis of getting between 1% and 5% of the value of the estate, depending on complexity and the amount of work done by the executor. And I think there's lots of people who think that, you know, they're a family member and it's inappropriate to charge a fee. This is what you do for your families. But, you know, an executor has a ton of work to do. We talked about all the things just prior to this, but, you know, all of the work in going to the accountants and getting taxes done, going to the lawyer's office to get the grant of probate, meeting with realtors to sell the house, going in to sign documents to sell the house, going to all the banks and getting all the bank accounts closed, dealing with all of the cancellation of identifying information. And then if you have a fight on your hands with beneficiaries and people calling you names and telling you you're doing a terrible job, all of that is a lot of work. And my thought is that an executor, there's no way that any beneficiary is even getting one dime unless the executor does his job. And so it makes sense to me that if an executor is going to spend 100 or 200 hours doing the work in the estate, they should be compensated because everyone else is just getting free money. But it's always, you know, the executor always gets to decide whether they want to charge the fee or not. The executor's fee is taxable. So it means you, as an executor, if you collect that fee, you have to claim it in your taxes in the next year. And usually the lawyer will work with you to determine what is the most appropriate fee, again, depending on work done. We usually encourage executors to keep track of their hours and the work that they did so we can kind of estimate how many hours they worked on the estate. The executor can also get their expenses. So if you're traveling to the lawyer's office and traveling to the accountant's office, and maybe the house, maybe there's a farm and you have to travel out there to deal with it, all of that mileage is also recoverable. If you have to buy ink for your printer or stamps to send letters, all of those are also recoverable. And those expenses aren't taxable, but that's just something you get reimbursed. If the beneficiaries disagree with the fee that you're proposing as the executor, then the executor can go to court and have the court set the fee. And I'm finding that there's a lot more fights about executor fees, and so I'm encouraging people now, if you are going to do a will, to try and set that fee in advance, so now there won't be a fight about the fee because you've decided what fee that executor is going to get, and they could waive it. But generally, they wouldn't ask for more than that fee. But then at least everybody knows you expected them to get a fee, and generally the beneficiaries are not going to be upset about that fee. Okay, so those are that's kind of the general overview that I give in terms of the most asked questions in estate administration. But now I'm happy to answer any other questions you have.
Doris, while people have a chance to think about questions and write them, I'm wondering if you can kind of address a little bit of the question. If I was going to do a fairly simple estate, based on what you said, not the amount of money, but fairly straightforward, is there kind of a guidance as far as timeline? Like, should that I be able to wrap that up in a year? Is it very common for estates to go on for a longer time period, something like that?
Mm-hmm. So I would say that if you, as an executor, get on it right away and apply for probate right away, so you're in that first 30 days applying for probate, and then you have your grant of probate 2 to 3 months later. At the same time as you're waiting for probate, you're getting the taxes done. Then within about 6 months, you could be ready to do your first distribution, providing there's no problems, right? And then you could be asking for the clearance certificate, so that within, from that 6-month time frame, maybe you have 8 months or 9 months to wait for the clearance certificate. So within a year, you could be completely, or just over a year, you could be wound up in an estate. So I'm going to say most estates take about a year to wind up if they don't have any problems. If they have problems, you could still be in year 10 dealing with an estate.
And Doris, we know that at some points at this time of someone's life that you're not changing wills or anything like that. So if I've purchased one of those will kits and I haven't been to see a lawyer, I can still then seek a lawyer's help at this point in time when someone passes away to help me interpret a homemade will still. It doesn't have to be a lawyer-driven will.
No. So any will you have, and wills come in all shapes and sizes. So we generally like people to seek out some legal advice to do the wills, but certainly they come in handwritten notes and stationer's forms. And so if you have a will like that, and especially if you have a will that you don't quite understand, then you should definitely seek out some legal advice to figure out how exactly you should deal with that kind of a will. The most famous holograph will, a will done in your own handwriting, was one that was done on a tire or a bumper with a farmer who died in Saskatchewan, and he wrote all to his wife and in blood because he was dying under this tractor. And that tractor part is now on display at the University of Saskatchewan as the most famous holograph will in Canada. So they can come in the form of tractor tires or handwritten notes. And all of those are things that for sure a lawyer can help you with. Oh, I see. So the question is, my nephews get a % of my grandfather's estate and want to know what the amount will be. What do we tell them? So I would say that if your grandfather is still alive, the answer will be that you don't know what that is at this point. And I really, as much as I'm sure they want to know that amount, I think that one of the most dangerous things an executor can do is tell people what they're going to get, because beneficiaries have a habit of, as soon as they know the amount, they start to spend it, either in their head or really spending it. And then what happens is you immediately have people who are desperate to get the money from the estate because they've already spent it. And so I think you need to say, look, estates take time. You need to have some patience. You're going to see the value of the estate when the probate is done. But even then, you have to be careful, because the probate determines the value of the estate at the time of death. And then you have to remember that from that, you have to subtract taxes, lawyers' fees, accounting fees, executor fees, and only then will you determine what their percentage is worth. So I think you can legitimately say that you don't know.
Perfect. I think we have someone typing a question. Yeah. Oh, no, just a thank you. So please feel free to keep typing questions if they come to you.
Yeah. Maybe I'll just talk a bit about prepaid funerals while people are thinking of other questions. So it may be that as an executor you're faced with the fact that there's a prepaid funeral, and I think most people think that if they are told there's a prepaid funeral, then all of the costs are paid. And I think you have to don't be shocked that in fact there's going to be at least a few things that aren't paid. So generally funeral homes will not allow you to pay in advance for flowers and food, because those are such fluctuating costs that they will insist that those only be paid at the time. But I think you have to be vigilant if you're going to deal with a funeral home with a prepaid funeral, because there is the chance that the funeral home will say, oh my gosh, no, none of these things were included, and so therefore they just keep trying to add costs on to what has already been paid. And funerals can get very, very expensive. So it is important to don't I think feel intimidated by the fact that you're trying to save money even in the estate. I think lots of people feel intimidated to ask if there's cheaper coffins or cheaper choices for cremation, and I don't think you should feel intimidated by that as the executor. The next question we have is, does the legal counsel provide advice concerning the tax implications of an inactive holding company, or is this done by a tax accountant? That would generally be done by the tax accountant in respect of an inactive holding company. And the tax implications would really be usually the deceased is going to own the shares of that holding company. And the question will be, did the value of those shares in the holding company change from the time they acquired the shares to the time of death? If they increased in value, there will be a tax to pay on the increase in the value of those shares. And then the question is, what is that holding company actually holding? If they're holding land or they're holding money, then you still have to get that out of the company, and there could be a tax implication to doing that. It all depends on sort of how that company is structured and whether there's shareholder loans. So for sure the tax accountant will help you wind down that holding company in the most tax efficient way and get all the money out of the holding company in the most tax efficient way, but also answer the question about whether it may be better for the beneficiaries to just take the shares of the holding company rather than winding it down. So you don't always have to sell everything or liquidate everything in an estate. You can take those things as they exist at the date of death. An interesting parallel to this question is the one thing you don't have to probate for, interestingly enough, is a company. So if you have shares in a privately held company registered in Alberta, in order to transfer the shares to the beneficiaries in Alberta, the corporate registry does not require probate. And so that's very interesting, because I've had estates where the majority of the value of the estate is held in the corporation, and that is quite true for many business people. And so while when we probated, we didn't have to deal with, well, actually, in this case, we didn't have to probate because everything was joint or in this corporation. But the corporation was worth like $167 million or something like that. It was a crazy thing. The person had bought, was an immigrant and bought all these holdings in Edmonton. Anyway, and so we didn't have to actually probate, even though that estate was worth such a crazy amount of money. So the answer was the situation involves cash holdings only in that holding company, and the dad is set as the sole shareholder. So that one should be pretty straightforward in terms of being able to deal with that. But still always important whenever you're going to deal with anything involving a corporation to get some tax advice from the accountant, because man, that the tax code is 2,500 pages or however many pages it is for good reason. There's all kinds of ways to save some tax involving corporations, so it's a good idea to ask that question before you just go ahead and cash everything out or close down the corporation. Okay. I thought my little group was going to be filled with questions.
So we will still have a bit of time to go through questions. As I had mentioned before, oh, is it too late for the importance of tax advice?
When is it? Well, it would be too late usually after you do something. So if you cashed out the corporation, if you and then filed a tax return on that basis, that's when it's usually too late. But often you can still go back and refile. Like if you made a mistake, usually the tax department's pretty forgiving and gives you some chances to refile if you truly made some mistakes. So it depends on the mistake that you made. But I would say it's never too late to at least ask the question about whether you can go back and do something different. Just while people are still thinking of questions, another thing that you might want to consider if you're the executor is if the will doesn't deal with how are you going to divide up the things in the house, you should think about how you're going to do that. Because if a will provides for everybody to get an equal share, so my children each receive an equal share, that is hard to fight about. But you're not going to divide a grandfather clock or a grandmother's brooch or a wedding ring into 4 parts. And those are the things that actually can cause families to break apart and never speak to one another again. And so I always think that a strong executor, a well-chosen executor, can kind of keep those families together and try and get them to, get together for Christmas the next year. And so as an executor, I think it's important to think about what is a good way to divide the things in the house if there isn't anything in the will. So the solution I like is to say you'll pick numbers from a hat or you'll pick birth order or something, and that's how people will choose articles from the house in the first round, and then they reverse the order and they just keep going 1, 2, 3, 3, 2, 1 until they're done choosing things in the house. Sometimes you'll do an inventory of everything that's in the house, whether by video or by writing out what's in the house and sending that to everyone, and then they can choose what they want. And if more than one person wants an item, then you can pick names from a hat. And so there's lots of ways to do it, except that you don't want to have no system, because that just causes lots of trouble, and then people start to fight, and then you're probably going to end up in court in terms of trying to solve those problems.
Thanks, Doris. And again, as we're wrapping up, if any questions pop into your mind, please go ahead and type them. Just on the screen, you will see that we have a little document or a little note here about planning for the future. And we know that your journey as a care partner of caring for someone living with dementia, you have focused on providing comfort and pleasure to the person you're caring for. And as a result, many of you have probably given up many sources of your own comfort and pleasure. And so we really want you to think about, as time goes on, how you're going to reconnect with that. So I'm just going to quickly show a few documents we have regarding this. And so we just simply have a one-page thing, and it's called My Bucket List. And this is really trying to get you back to some of the things that you've wanted to do and you've probably given up as when you were a care partner. So that's something that we think is pretty important. And obviously you do not have to use our little sheet there for it, but it just kind of helps you think about that what you're going to do. We know many care partners say after the person living with dementia has passed away, they felt a little bit lost and they weren't sure what to do. And so this kind of gets you back on track. The other thing we really want to remember too is that there is life after Alzheimer's or dementia. And again, to try to look at that using some type of a list. From the Alzheimer's Society, we want to remind everyone that we do have support groups and we do offer ongoing support. So if you simply just want to have a chat with a staff member, want to meet some other people who are going through that, we will have the support groups in the Edmonton area listed here for everybody to download, which I think everybody was on it in the past as well. So these are the documents that we have available, the kind of the bucket list, my sources of comfort and pleasure, the questions for reflection. We do have those listed here as well. Again, these are things you can print off in a few days to take a look at. I think anytime you want to reflect on some of the information that Doris has talked about, it gives you a nice place to put it in writing. Our speaker's notes and today's presentation will be there, and as well as I said, the support groups. The important part is how do you actually find it to download? This is where you can find the documents. So in the same kind of area you're in, if you go to the discussions tab, you scroll down to the blue header titled Live Meeting, you click on End of Life. This would actually be session 4. Keep clicking and you'll be able to choose and download all of these accompanying documents. If you're having trouble doing that, just give the Edmonton office a call and we can either walk you through or we'll just send you out the copies. So I think that's all the questions we have. Doris, we do want to thank you. And before we let you go, we just have one question for you. And the question is, how do you remain hopeful when working with people living with dementia?
I think I remain hopeful because I hear the wonderful stories of what the caregivers get out of their caregiving, the love that they feel and the love that they show, and the fact that they're, sometimes on a very sad and frustrating journey is always uplifted, I think, by the fact that love can conquer all kinds of things. And so for me, that's certainly what I see and what I feel every day when I talk to someone who has devoted their life to someone.
Thank you so much, Doris, and thank you everyone who has joined us this evening. If most of you are from Edmonton in Northern Alberta, have a safe trip home. And for those of you at home, we're very jealous of you that you're in your warm, cozy house. So again, thank you everyone. And in the new year, we hope to be offering more webinars as well as another Seeds of Hope session, and we'll be determining that in the near future. Thank you, everyone.